Hi there. I'm Dr. Suzanne Bechtel, a passionate legal educator dedicated to making legal studies clear, practical, and even a little inspiring. On this channel, you'll find a growing collection of videos designed to help you prepare for the Certified Paralegal exam. It covers key topics, breaking down complex concepts, and offering study tips that actually stick. If you're looking for a deeper dive, check out my Teachable School, where I offer structured courses, interactive tools, and exclusive resources to support your journey towards certification. Watch this video to the end and you'll find a coupon code for a discount. Don't forget to subscribe and explore the playlists. Your success on the NALA CP exam starts here. Now, before we move on to the lecture, there are two important disclaimers. First of all, this is not considered legal advice. Everything shared here is designed to support your learning journey. Also, I am not a lawyer. This course is designed to help you understand the concepts of the exam. This lecture on the corporate organization will focus on the roles of the officers, directors, and shareholders in the operation of the corporation. And we're going to give attention to the authority and duties of the directors and to the rights of shareholders. Specifically, these topics are covered in this lecture. And don't forget, the review notes are available, and you can follow those along with this, as well as the resources are included in the review notes. So I don't have those listed. They're listed here, but they're not going to be discussed in this lecture. All right, so the corporation acts through its agents. Their officers, directors, and shareholders are a big part of that, and the board of directors as well, which is most are required to have one. The closed corporations sometimes don't. And the size of the board of directors can be from one director to several. And the directors of smaller corporations, they can also be employees, officers, and shareholders. So they can be smaller places, they can be holding more than one role. The authority of directors and the directors' duties are covered in this slide. And the shareholders elect the directors, and they're given the statutory authority to make most decisions regarding the operation of the corporation. The board of directors elects the officers of the corporation and delegates authority to them. And the board may delegate some types of authority to the officers, but the directors must maintain the general supervision of the activities of the officers. So, because directors are generally responsible for the actions of the officers they elect. The board of directors might also delegate authority to committees. Committees comprised of members of the board of directors. The right to this delegation is typically granted by state statutes and bylaws of the corporation. The board of directors is responsible for overseeing the management and affairs of the corporation. The responsibilities of the board must be to oversee, and they'll vary depending on the size of the business of the corporation, the type of purpose it has, whether it's publicly traded or not. Some statutes can help you determine this by looking at what a publicly traded corporation might have to have oversight of. Committees can't take on everything, so the Model Business Corporation Act comes into play, and it specifies that committees can't be used to authorize dividends or distributions to the shareholders of the corporation. They cannot approve to propose to shareholders the actions required by law to be approved by shareholders. They can't be used to fill vacancies on the board. They can't amend the articles of incorporation, adopt. Anyway, this is a rather long list in the review notes. So committees are great, but they are not able to do everything. And I apologize. Oh yeah, we got this. Okay, so I'm trying to figure out the board of directors may also delegate to committees. Okay, just making sure the slide was making sense in relation to my lecture notes. There's a lot of good information in the lecture notes about this slide. It's a lot to go into here verbally, but there's a page, basically a full page that'll help you get more familiarized with these areas. All right, the business judgment rule. This is an important one. This is definitely on the exam. The business judgment rule protects directors from personal liability for informed decisions made in good faith where there's no conflict of interest and the director feels the corporation's best interests are being served by the decision. It protects directors and officers from personal liability for business decisions made in the following contexts. Kind of a repeat, but made in good faith, where the director or officer has no personal interest, where the director or officer is informed with respect to the subject, where the director or officer rationally believes that the business judgment in question is in the best interest of the corporation. So a few things going on there. But they generally are not held personally liable for damages caused to the corporation or its shareholders if these decisions are made in good faith. Compensation of directors and their personal liability. The last one was for personal liability of directors. This next one is going into the personal liability and compensation of directors a little bit more. But basically we look to the compensation. Directors may or may not receive, no, I apologize. Directors may be held responsible. So the last one was about how to avoid responsibility by working in good faith. The last slide was. This slide concerns the director's personal liability for other acts that don't fall into the business judgment rule, such as breaches of fiduciary duty, breach of duty of care, or breach of duty of loyalty, making unauthorized acts, those things that are clearly beyond the scope of their authority. Their negligence is not protected. Fraud and other illegal acts are not protected. Acts that are controlled by state statute or the corporation's articles of incorporation or bylaws that provide for personal liability by directors. They're compensated, but they don't have to be compensated. It can go either way. It's usually set by the amount of compensation is usually set by the board of directors. And it's possible that it's been limited to the shareholders, and state statutes might also have some bearing on how this compensation works. There are also some issues with compensation in not-for-profit type of corporations, so the care has to be used. So we'll get that from that angle. Next slide. So compensation, there's indemnification. So there are provisions typically in the Articles of Incorporation and bylaws that provide for indemnification to reimburse directors for expenses incurred by them to defend a lawsuit to which they become a party due to their position with the corporation. So that's the indemnification piece, that those expenses would be reimbursable to a director who's defending themselves in a lawsuit to avoid personal responsibility. So they can be either mandatory or it can even be prohibited. So some state statutes may say you can't do it at all. So that's just going to depend on the statutes and whether it works. One moment here, fix something. All right. I think that's it. On the next slide, though. Officers serve directors serve terms. They're voted, voted. They are elected by vote of the shareholders, and the shareholders can decide to ensure the continuity of the management by staggering the terms of the directors. Um, Typically, a director can resign at any time for any reason. They would give notice in writing to the chairman on the board, and can be removed by the shareholders with or without cause. The state statutes and the articles and bylaws of the corporation would have some definition as to removal. And in some states, the board vacancies may be filled by a vote of the remaining directors. So, and in other states, they need a special meeting of the shareholders to elect a new director. So, the famous words the lawyer loves, it depends. Meetings of the board of directors, actions can be taken by resolution passed at a meeting or by written consent, signed by all directors, annual, so they typically will have meetings, and how consent is defined is in the articles, typically on how a vote passes. Annual meetings of the board of directors are generally held because they review important events that have occurred over the year. They take actions on matters requiring action for the upcoming year. And you've got to give proper notice of the meetings of the board of directors in accordance with state statutes and the articles of incorporation and bylaws of the corporation. The board of directors must have a quorum to take action at a meeting, which is the minimum number of individuals who must be present or represented at a meeting to take a valid action. The quorum for the meeting of the board of directors is set by the corporation's bylaws or articles of incorporation, and also there can be state statutes that apply to this. These meetings are kept, minutes are kept of these meetings, and written consents of the board of directors and shareholders are kept and filed in the corporate minute book, and other important corporate documents go into the minute book. Meetings of the board of directors may also be held by telephone sometimes, or web conference, other types of means, so everyone can participate. Board of directors elects the officers of the corporation, and their titles and duties are usually set out in the bylaws. Some states have statutes that require that a corporation elect certain officers, such as chief executive officer or chief financial officer. But others, we have names. These are some examples of some names. Officers are generally held to the same standards of conduct as directors of the corporation, and they owe the same duty, fiduciary duty, duty of care, duty of loyalty to the corporation, to the corporation's shareholders. White-collar crime and corporate compliance programs. So white-collar crime is an important issue to the board and the officers and the shareholders of any business, including corporations. Criminal prosecution could ensue, and it often does include prosecuting corporate executives. Corporations are as far as compliance programs, they're proactively adopting corporate compliance programs to prevent and detect criminal conduct within their organizations. There's a lot, I'm just going to this, it's really, corporate compliance is a great way of area of work for the paralegal. So I'm just bringing that up in case you want to do this someday. Let's see, shareholders' rights and responsibilities. The shareholder or stockholder holds stock in the corporation. That's what they are. And the shareholders are the owners of the corporation, and they can be individuals or other corporations or entities. They have preemptive rights that are given to them that allow them to purchase new shares that are issued by the corporation before persons who are not current shareholders may do so. And it allows current shareholders to preserve their percentage of ownership in the corporation. Preemptive rights may be granted by state statute or the corporation's articles of incorporation, and they're typically they're typically something used only in smaller corporations. Shareholder rights include the right to inspect the records of the corporation, and shareholders are generally protected from personal liability for the debts and obligations of the corporation, unless the corporate veil is pierced, and we've already talked about that in previous lecture and topics. So shareholders have meetings. They'll participate in the management of the corporation by electing directors and through their participation in the annual shareholders meeting. That's how they get control over the business. Corporations are generally required by state law to hold annual meetings of shareholders, and if the board doesn't hold meetings in accordance with its bylaws, shareholders may move for the court to compel the corporation to hold that meeting. And in some states, shareholders may be granted the right to accumulate their votes for directors of a corporation. Cumulative voting rights give minority shareholders a better chance of electing at least one director to the board of directors. And in lieu of meetings, shareholders may take actions with unanimous written consent using forms. And special meetings of shareholders can be called between the annual meetings to allow shareholders to vote on extraordinary matters. And they have to be given notice of all shareholder meetings in accordance with state statutes and the corporation's bylaws. Shareholders may vote in person or by proxy, and a proxy is authority given in writing by one shareholder to another to exercise the shareholders' voting rights. A quorum of the shareholders must be present to take action at a shareholder meeting. Some acts that must require shareholder approval: election of directors, amendment of bylaws, amendment of articles of incorporation, etc. Restrictions: shareholder agreements can restrict stock transfers. We did already mention that one of the advantages of a corporation is it's easy to transfer corporate stock. But the transfer of shares of stock may be restricted by shareholder agreements. Buy-sell agreements are agreements among shareholders that provide terms for the purchase of the shares of a shareholder who withdraws or dies. Shareholder lawsuits include individual actions or representative actions and derivative actions. We talked about those in a couple of lectures ago. If you're injured by an action of the corporation, you can bring or an individual or a direct action against the corporation. Shareholder actions may be brought, representative action can be brought against a corporation by a shareholder on behalf of the entire class of shareholders. And we've talked about derivative actions. They are brought by one or more shareholder to enforce a corporate right or remedy a wrong to the corporation because it's being controlled by the wrongdoers or for other reasons. And so for that reason, fails or refuses to take action for the corporation's own protection, and then a shareholder can file a derivative action. Last slide, paralegal's role. Lots of cool things the paralegals do in this role. You can also, don't forget to review the review notes because there are some review questions to give you some practice. All right, thank you. I hope you got some good information from this video lecture. Don't forget that I have a Teachable school account. Here is the address for that, mayananda-s-school.teachable.com. The name of my school is Mayananda. And also there's a coupon here for you to save some money. And finally, good luck on the exam. And don't forget to like, share, and subscribe.